Why are you wanting to submit a whole bunch of crap that just muddies your point? Why wouldn't you be trying to make it as simplistic and to the point and crystal clear as possible? Hey guys, this is Jules with True Crime Reactions. Disclaimer. Everything stated in this video is my opinion and my opinion only. And just like everything else in these cases we discuss here on this channel, everything is alleged. Okay, we have a new document in the Idaho 4 case, and it is in reference to the actual Frank's motion. Now, we have been going through all of the motions to suppress that are included in this argument. The next one that we are going to be going over here on this channel is the one about somebody in Idaho apparently did something that the defense now wants suppressed. But what we have today on Saturday, November the 23rd, is actually an answer from Judge Hippler himself regarding the Frank's motion hearing request. Now, this is a little ridiculous in my opinion, but I do agree that rules are rules. Just like the state came down on the defense claiming that they exceeded page limits, and I just feel like it's stupid and petty. I would have said the exact same thing if it was the defense saying the exact same thing about the state. This is literally a fight for life. There shouldn't be a freaking page limit on that fight. I find it absolutely preposterous, and just because it is a rule doesn't mean that it should be. Now, when it comes to the court's order for the Frank's motion, this has not been denied, but they want things to be a little bit more specific, which is just keeping to theme with the irony that has already been these motions to suppress. The main arguments, besides the fact that the defense is stating that Bryan Kohberger's DNA was obtained illegally, which is fight numero uno here, and all of the rest of the arguments that they have in these motions to suppress, they're complaining that the PCA that was used, Payne's PCA, is boo-boo because he literally copy and pasted everything from Blaker, which we know to be fact. We know to be factually accurate. Blaker's was apparently the very first PCA written, but yet for some reason was not the one that the public was originally given. But in their argument that all of this is copy and pasted and duplicative, their argument itself is duplicative. There is a very small section on the motions to suppress that is true and actual case fact, and literally the rest of the 17 to 20 something pages is literally copy and paste of the exact same case law that they're citing, the exact same constitutional fights that they're trying to fight, the exact same cabinet case, the Georgia case, the drug test case, all these cases that to me, in my lay opinion, don't really have anything to do with anything. I want to get down to the facts because the facts are all that matters in this entire situation. Now let's go ahead and read over the Frank's motion order because there's some amendments and changes that apparently need to be made, and he's giving them 4 days to do so, which is wild as crap to me because right now it's Saturday. Obviously, this was not posted today, but it was posted yesterday. It was filed on November the 22nd and signed on November the 22nd. And he is literally only giving them until Tuesday, the 26th, to fix this. That's 4 days. 4 days and work through the weekend because I don't like what you did. Now, what he says in here makes a lot of sense, honestly, but I don't know why the defense is playing this game either. Because it literally sounds like they're about to get berated for the exact same thing that they're berating the state for. And this is not the kind of fight that I want to see happening in this case. I want to get to the facts. I honestly don't care about none of this policy stuff. Half of these rules need to be rewritten and thrown out, and we need change in a lot of areas. So for this kind of stuff, yeah, it matters. Obviously, it still matters. But to me, I want to get to it. All right? I want to get to it. We're going to go ahead and just read through this. This is the order regarding the Frank's motion. Before the court is defendant's motion for Frank's hearing from November 14th of 2024 and memorandum in support of motion for Frank's hearing November 18th. That is part of the filings that the defense team stated they were going to be handing in person this past Monday. Accompanying the motion are 38 exhibits comprising over 2,000 pages. Unfortunately, defendant's memorandum largely fails to identify with particularity the relevant portions of the exhibits, instead referring simply to the exhibit number without identifying the precise pages at issue, and we have a footnote, number 1. It says, by way of example, defendant cites generally to Exhibit D9 for the proposition that law enforcement's vehicle expert felt more comfortable setting the date range of 2011 to 2013 for the Elantra. That exhibit is over 100 pages of duplicative emails. Defendant does not identify which email supports his proposition. The court will not do the counsel's job and scour the exhibit to decide what portions defendant must be suggesting support his assertion, which I agree. You should be very specific. But then again, like I've mentioned, when it's come to evidence that I've had to turn in for things, I couldn't sit there and highlight or put an arrow. There couldn't be anything on it. So they'd literally have to go in here and purposely delete certain things in order to only leave in the things that are important. But what if there's like context around that? What if some of it needs to be in there? See, this is going to take longer than 4 days, I promise you. There's no way. Thus, the court is left with the unenviable task of sifting through pages and pages of largely irrelevant documents to ascertain what portion defendant may be referring to. The court is not required to search the record looking for evidence, and they're citing a case of their own from back in 2014. Consequently, if defendant wants the motion to be considered, he must file a revised memorandum identifying the relevant portions of the record by page number and line number if referring to testimony for the facts asserted. In addition, defendant must resubmit his supporting exhibit to exclude portions that are not relevant to the motion. Because the state is under a deadline to respond, the court will allow defendant until Tuesday, November the 26th. To submit the revised filings. So because of the state's deadline to respond to said filing, you can't give them more time to do what you want to do because obviously they're trying to actually fight a fight. And if there's context stuff in there that needs to stay in there, they're going to have to go through all of these pages and be very specific. But I also do understand if it were me, okay, if it were me and I was truly innocent, I wouldn't be trying to put a whole bunch of air and fluff and filler in there. I would be direct to the point so that there's no mistakes in what I'm trying to say. But this sounds like it's just a bunch of nothing, which is also the same for the state. The state has had a bunch of nothing. So this case, literally every single document that comes out, there's more questions and more like bigger issues. There's just bigger issues and more problems. Now this thing is 2,000 pages. I want to know if any of this stuff that he's complaining and griping about, if he's even read any of the facts, or if he saw it and was like, nope, they got to redo this because I'm not dealing with it. Did he look at all to see what the story was that they had in mind for how they believed that Bryan Kohberger's DNA was obtained illegally? Because if that was in the back of his head with facts proven, but then again, if you're there trying to prove a point, you definitely want to make sure that all of your I's are dotted and all of your T's are crossed and there's nothing that they can do to come back and try to combat your fight. So I don't know why the defense felt like it was an okay situation if this is what they did. Everything's duplicative. There's a bunch of repetition. It makes it very, very cloudy to see what needs to be seen. You'd think that they would want it as crystal clear as possible. Now, the other document that we have is also the defense's objection to bringing in those special assistant attorneys general that the state has now re-asked to have joined. But I mean, I don't know how much you can really say that you can object to it whenever they've literally already been present at the hearing. He's already signing documents. So I don't really know how much of a fight they can really put up with that, honestly. So this is what their objection states. Comes now Bryan C. Kohberger by and through his attorneys of record and objects to the amended petition for appointment of special assistant attorneys general filed November 19, 2024, and the request for decision without hearing on same filed November 20th of 2024. The grounds for this objection are that the state has not articulated good cause for the appointment. Idaho Code does not authorize multiple attorneys general, while Mr. Kohberger will be denied the right to a fair trial if the state is given the broad authority to appoint multiple special assistant attorneys general without any specification of who and how many. Remember, I mentioned that the only difference between the most recent request for this and the original one is that it takes away the names and leaves a generalized title, meaning that anyone could be inputted into that. And then they cite Idaho Code 312603B that states the prosecuting attorney may petition the district judge of his county for the appointment of a special assistant attorney general to assist in the prosecution of any criminal case pending in the county. And if it appears to the district judge to whom such petition is addressed that good cause appears for granting such petition, the district judge may, with the approval of the attorney general, appoint an assistant attorney general, meaning just one. And I guess they're thinking there's going to be multiples, but I guess there really sort of is, because we had two at the last hearing. The plain language of the statute allows, upon a finding of good cause for a, which is actually un, if you're going to actually do this right, because you're supposed to put the in behind the a whenever the next word is a vowel, for an assistant attorney general to assist in the prosecution. The state's petition seeks to give Idaho's criminal law division of the attorney general's office the broad discretion to appoint as many designees as it sees fit. The authority sought in the proposed court order is that the Deputy Attorney General Jeff Nye and any other Deputy Attorney General selected by the Attorney General's office be appointed as Special Assistant Attorneys General to assist the prosecution of this case. This language, when coupled with the explanation in the petition and the letter that accompanied the petition, is to grant Mr. Nye or his designee carte blanche authority to choose assigned Deputy Attorneys General as may be appropriate. The authority sought in the petition in draft order is without any rationale for good cause and is beyond the scope of the authority set forth in the statute for a attorney. I'm just going to assume that's just how they have to put it in here, but I know it's getting on my nerves just a little bit. This is different than what the state did earlier in this case. When the state first sought the appointment of the Idaho Attorney General's office in April of 2023, the petition set forth two specific names. Remember what I told y'all. The time for Mr. Kohberger to object is now, because Idaho case law indicates that once a special assistant attorney is appointed, there is no collateral attack available absent a showing of an unfair trial. It is important that Mr. Kohberger have knowledge of what prosecutors are acting on behalf of the state to preserve all issues associated with a fair trial. So we have a second footnote here, but that means that I missed the first one. So the first one is actually at the very end of this sentence right here before we started reading this citation. And it states, defense counsel reached out via email to the state to seek an understanding of the state's intentions. They have not gotten a response from the state. So that's interesting. Okay, footnote number 2 states, the state currently has the assistance of the United States Attorney's Office for the District of Idaho. United States Attorney Joshua Hurwitz and Assistant United States Attorney Tracy Whalen have conducted grand jury proceedings, the extent of which is only known through over 70 subpoena returns and 2 subpoena duces tecums. Okay. This is not a routine matter as asserted by the state. This case is a very high-profile case, and as such, the court has taken many measures to protect sensitive information. These measures include a non-dissemination order, sealed filings, and protective orders. The case has a huge amount of discovery, over 60 terabytes of information. It is critical to the preservation of the confidential nature of this case that this court and the defense know who has access to the case file and who is acting on behalf of the state as a prosecutor, which I understand that, because why take the names out? Aren't we over with elections? Isn't whoever is in the seat going to be in the seat for the remainder of this trial? Why are we having to take out very specific names and make it generalized? It does sound like they're trying to just have whoever they want look at this case whenever, as far as I understand, you have to have like special court permissions if you're not on the list of approved people whenever there's a gag order anyway. Like it literally has to go in front of the court and you have to get permission. So them just putting like generalized labels might stop the state from having to go through that red tape, which honestly, I agree is some boo-boo. As such, counsel for Mr. Kohberger took the prosecutor up on his offer on the letter to the court and emailed with a request for clarification relating to the requested broad authority for Mr. Nye, no answer case, which is the exact same thing that first footnote said. Upon a showing of good cause and a finding of good cause, the court should limit the appointment of the Special Assistant Attorney General to a single attorney or at a bare minimum to a specifically named prosecutor. Under a plain reading of the statute, there is no statutory authority for more than one attorney or broad discretion of an open appointment to an entire attorney general's office. A hearing is requested on this matter, as it is not a routine matter to give an entire legal division of the Idaho Attorney General's office authority over who to appoint as prosecutors in this case. So if the judge decides to just grant this without having a hearing, I think my commenter was correct. It's going to actually show the biasness of this judge. But if he has the hearing, then he obviously is willing to hear both sides and see what everyone has to say in real time. But I agree, leaving it broad and vague like that is not okay. And they're right. It's leaving it literally open to the entire office of the AG. Now, the only other two documents on here are the formats that we always see whenever the state responds to the defense's supplemental request for discovery. It's just a huge line list of documents and them stating that they're going to keep doing whatever they're supposed to be doing in accordance with the Idaho rules. That's basically all they say. And it's the same thing for this sixth motion to compel as well. So basically, they want the entire state of Idaho to be able to do whatever they want with this case without having to get the special permission that they technically need in order to put their fingers in it in the first place. And then while they're having to worry about who's actually prosecuting the case because of all this other stuff happening, they also have to go in and do all these edits and be super, 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 super specific. Like, I understand both sides of the argument here. I understand the defense's argument because that's bullshit. You should definitely have somebody assigned directly. Their names should be on the paperwork and not just a signature after the fact. When it comes to appointing the counsel, that very specific counsel should be named. It shouldn't just be, oh, this office gets to do whatever they want to. That's crap. But I also agree with the judge. Like I mentioned, why are you wanting to submit a whole bunch of crap that just muddies your point? Why wouldn't you be trying to make it as simplistic and to the point and crystal clear as possible? And I don't have any reason to believe that the judge is exaggerating this situation, because that's been my big argument in all of these motions to suppress, that it's ridiculously, redundantly copy and pasted. So let me know what you guys are feeling about this situation down in the comments. Tuesday, we won't know if the deadline is met. If the deadline can't be met, then I'm expecting something filed asking for an extension, possibly. But we won't know for sure if anything got actually filed this coming Tuesday until probably Wednesday when it shows up on the case summary. But it's a sealed document, so we won't be able to see it anyway. If you like the way that I present this information and give my opinion, please don't forget to leave a like on the way out, subscribe to the channel if you were not subscribed already, and please don't forget to make sure that your notification bell is set to all so you don't miss any of my rants, reviews, reactions, updates, or deep dives. See y'all.